speaker, who is here in New York, is Professor Alejandro Garro. Professor Garro is an adjunct professor at Columbia Law, Parker School of Foreign and Comparative Law. Among his many contributions to the field of comparative law and unification of law, Professor Garro has been a member of the Principles Working Group, and specifically the 2010 Principles Working Group, though he has participated in prior working groups since the 1990s. He's brought to the project much needed welcome focus on Latin American law and legal systems, as well as an Argentine academic and practice background and experience with common law here in the States. Professor Garro will highlight some aspects of the principles that are familiar both to the common law and civil law traditions as they've been incorporated into the principles. Alejandro?
I'm waiting for the delay to press, but it's in the same place. Well, good afternoon, everybody, and it's a real pleasure to be here. I thank very much Richard and the branch of Esquire Patton for this event. This is not the first one in which I participate. We had another one in this, perhaps, same room. Probably the issues that are the more important ones are the ones expressed by Professor Bonnell, which talk about the potential usefulness of the principle. I think that that's what I'm probably going to provoke most of your questions, but yet in order to get a more accomplished idea of what the principles are about, the organizers have decided to focus on specific provisions. So the way in which the program is divided is I will be in charge of discussing and picking and choosing among a few areas which are common to both civil and common law, followed by Dr. Bergman, who will talk about principles which are issues that legal institutions are important to in civil law and not so much in the common law, and Professor Garro later on will focus on those who are common in the common law and not so much in the civil law. So in this area, which I have been assigned to discuss, there are three different issues, and so I'm going to be moving you from one chapter of the principle to the other. Tab 10 of your handout materials, which have a comprehensive credits of all the versions, 1994, 2004, 2010, and all of them are part of the discussions that we're going to have this afternoon. The area of formation of contracts is the area of Chapter 2. It's a good sample to pick up in Chapter 2, this Article 211, that you will see is not present in the Vienna Cell Convention. The Vienna Cell Convention, that are known as the CIG, is a sort of a sister text with the UNIDROIT Principles. Someone said there is some incestuous relationship because the same people who were very much involved in the drafting of the CIG, later on some of them had a stellar protagonism in the drafting of the principles. But there are differences, and I think that one of the interesting is that under the CIG, which is the law in the United States, jurisdictions, there are a group of 22 provisions of Articles 14 to 23 dealing with offer and acceptance, whereas in the UNIDROIT Principles there are 22 provisions in Chapter 2, Section 1, dealing also with offer and acceptance, which shows you that on the one hand, the principles have taken over and actually transcribed literally some of the provisions of the CIG, whereas adding other provisions that were not present in the CIG. That's the complementary function that one may play with the other. That's a topic that we may discuss later on. On the area of formation 211, talked about one manner of concluding contracts that may be achieved, even though there's not been a precise identification of the offer and acceptance. So this does not comport with the traditional set situation where the offer and acceptance are created individualized, but rather a situation where the parties engage in negotiations, later on start performing, and then the question is, do we have a contract? If so, which are the terms? 211 provides that the contract may be concluded either by offer and acceptance or by conduct of the parties sufficient to show agreement. A provision that, again, is not absent in the framework of the UCC as well as in the framework of other legal systems. The second point, and I need to a little bit brush you over many of these provisions, deals with another aspect of a contract, which is the content of the contractual obligation. This is a new provision that, again, is included in the Chapter 5 of the UNIDROIT Principles. The chapter that you will see have different provisions, at least from 514 through 519 of these principles, dealing with express and implied obligations, cooperation between the parties, the determination of the quality of performance and of the price, as well as the termination of contract for an indefinite period. Well, two of those provisions, the ones you have in front of you, 514 and 515, deal with a specific distinction of obligations according to their content. A distinction that, again, it may have been devised by René de Montg, a French legal scholar in the 19th century, but definitely was later on adopted by most legal systems, including, and this is why it is common to both common law and civil law, if you look at the Article 2306 of the Uniform Commercial Code, where you will have a definition of exclusive dealing, there is implied in that definition the idea that what the obligor is going to do is efforts to actually achieve, to perform the obligation. Well, similar provisions you will find in the German Civil Code, the BGB, looking at Section 611 and Section 631, where distinguishing between service contracts and the contracts to produce a work, also makes a distinction between this type of obligations that are defined in 514. One, the obligation to achieve a specific result. Second part of 514, the obligation to achieve or undertake the best efforts under the circumstances, or as paragraph 2 of 514 said, the effort that would be made by a reasonable person of the same kind in the same circumstances. The principles, in addition to its comments, have a good help of illustration, very much like the restatement of the law in the United States. And it gives a very good example of a distributor that promises that it will reach a certain quota within a certain amount of time, an obligation, and definitely is an obligation to achieve a specific result. If that result is not achieved, then there is a breach of contract, as opposed to the obligation by the same distributor to, let's say, put his best efforts to expand the production or the sale of a certain product within a certain time. It is the proof that such efforts have been undertaken which will determine whether or not that obligation has been performed or breached. And I think that is the relevance of this distinction that very much looks into the level of diligence that the obligor has put or has contracted to perform the obligation. And as you can see in the following article 515, how do you determine whether it's one type of obligation or the other? Well, the formula that the principles used in many other provisions, and hence the usefulness of the principle, it gives standards with a language that says regard shall be had among other factors, a text that you will see in other provisions of the principle. What factors? Well, of course, the terms of the contract in the first place. What are the term of the price? The degree of risk that has been assumed by the obligor, the ability of the other party, generally the obligee, to influence in the performance obligation. All these are matters of interpretation, and all these are matters of interpretation of contract that, in light of 514 and 515, may help an arbitrator or a court to determine what is the type of obligation, who has the burden of proof, has the breach occurred or not. Finally, the final point that the organizer asked me to address is in Chapter 6, dealing with the performance of contract. Here you find a situation where the contract, either because of the validity of the contract or some other requirement, requires to obtain a permission from a public authority. Permission from a public authority may be a license, whatever other type of authorization. Definitely the matter generally of public law, and it has its own public policy regulation, public policy which definitely will prevail over the otherwise applicable domestic law or the principle. But what many times that domestic law does not say is who is bound to obtain the permission. When is that permission needed to be obtained? Who should be the cost of that permission? What would happen if the response of the authority is neither yes or no? And time passes and there's no response. What if there is a refusal? what can you do with the contract? Well, these are subjects that are discussed in Articles 614, 6114 through 6117, out of which I have 2 minutes only to just see them superficial. One of them, 6114, tells you who has the burden to apply for a public permission, and at the same time tells you that whoever has that burden, which may well be the party located in the country where the public authorization is needed, also should bear the costs. Then 6116 tells you what is the situation, what happens when there is no answer on part of the authority, in which case there would be, of course, some kind of response on part of the legal system. If there is a gap in that legal system, the UNIDROIT principle may come in and tell you that, well, if the contract is invalid, it may be partially valid, not necessarily totally invalid. It's something that is consistent with the philosophy of the principle. And secondly, if the performance is run impossible, then the rules applicable to non-performance will apply. This is, in very briefly, what is this principle at this stage? Thank you very much for your attention.
Thank you, Alejandro. Obviously, we can only skim the surface of all these topics, and hopefully what comes from this exercise is an interest in reading more and learning more about the principles. I would like to take a moment for a commercial break and suggest to everyone, but it's not the commercial break you might expect, that you consider at the back of your materials is an order form for a publication of UNIDROIT, which is the UNIDROIT Principles 2010. This particular volume has very helpful comments which include illustrations that go beyond the scope of today's exercise, and it's a very useful tool if you're interested in learning more about or actually using the principles in a particular case. And thank you, Alejandro, for some of the common ground. As we get into areas of difference, we risk losing sight of the common ground. And so I thought it would be a good idea to start with that particular concept. There are lots of other areas of common ground that we're not going to talk about today that are in the principles, but I hope everyone be aware of the fact that they are there, and it makes for very exciting reading.